Welcome to the Chamber video replay of COVID-19 federal law updates for employees. As indicated, I'm Lisa Edison-Smith. I'm with the Vogel law firm, and I've been a labor and employment attorney for 23 years. I'm actually a certified labor and employment law specialist in the state of Minnesota. So all I've done over the past 23 years, for the most part, is labor and employment law. If you're watching this, you're probably an employer, human resources person, or small business person in the Fargo, Moorhead, West Fargo area and community. And I want to reach out to you and say, keep on keeping on. The last 3 weeks, I think, have been the most dizzying for me as an employment attorney, but more importantly, most dizzying for my clients that I've seen in the 23 years I've been practicing. You all out there have been faced with a barrage of different really challenging circumstances. Not only have you had to deal with the ever-changing effects of COVID on your workforce, on your customer base, with closure orders, and all of that variety of things, plus watching the bottom line, possibly layoffs. You've had to deal with trying to process just a variety of legislation, both at the federal level and at the state level, that is intended to give you some relief from COVID's effects in many cases, but it also provides rights to your employees to paid leave, to time off that may be at least a short-term burden to your business, and something that is difficult to process all in one time. Today I want to talk primarily about the Families First Coronavirus Response Act. The Families First Coronavirus Response Act is House Resolution 6201. That doesn't really mean anything, but what it really means is it's a piece of legislation that was intended by Congress for, basically it has multiple parts to it, which include food supplements and things that are unrelated to employers. But for employers, the primary effect is that it provides for paid leave requirements that you have to meet and paid time off for daycare closures and childcare that you have to meet. And it also provides a reimbursement mechanism for you. That's what the part of the federal legislation that I want to focus on. I will touch briefly at the end of our session on the CARES Act, which is a huge piece of legislation. The official version of it is, I believe, 335 pages long, so I'll only be briefly touching on that. So let's start by just reviewing some of the basics of the Families First Coronavirus Response Act. And I refer to that in the slides that you'll be seeing as the FFCRA. The Family First Coronavirus Response Act it is effective today, as I tape this, April 1st, 2020. It's not an April Fool's prank, I wish it were, and the irony of it is that you all out there are having to deal with and comply with this act and answer questions for your employers, and we, as attorneys, don't even have a complete set of regulations as I make this videotape from the Department of Labor and Department of Health and Human Services as to what your requirements are. So what I'm going to do today is I'm going to review the basics of the Act as we know them from the text of the Act and from the interpretations we've received so far from the U.S. Department of Labor. What I can tell you is what I'm saying today will likely change, and it will likely be further defined as the regulations are issued by the U.S. Department of Labor and as we, as employment attorneys, receive further guidance from the Department of Labor and try to get that information out to you. So I appreciate your flexibility. The situation is evolving even as we speak, and what we have found is it's difficult for even employment lawyers to stay ahead of what is the exact current status of the guidance that we're getting from the U.S. Department of Labor. So what you're looking at now is something that by now you should be familiar with, which is the employee rights poster under the Families First Coronavirus Response Act that is effective today, that should be posted in where you post your your work-related notices and in a conspicuous place in your workplaces. One thing I do want to point out is there are 2 versions of this poster that have been circulated, and you want to make sure that you have the revised version that indicates that it was revised March 30th, 2020 in the lower right-hand corner. The initial version of the poster was somewhat confusing from the U.S. Department of Labor, and it was amended. So make sure that you have that posted if you are subject to the Act. As I'll talk about in a few minutes, you're only subject to the Act if you have fewer than 500 employees. If you have more than 500, if you have 500 employees or more, I should say, you're not required to post the poster because you're not subject to the Act. So what does the FFCRA require basically? The FFCRA requires 2 things. Emergency sick paid leave be provided to employees, and what's called public health emergency leave under an expanded version of the Family and Medical Leave Act. And the leave can only be taken for designated reasons related to, directly or indirectly, the outbreak of COVID-19 that we are now all experiencing. Again, as I stated earlier, the Act applies only to those employers who have 500 or fewer employees. If you have 500 or more employees, there's other legislation that will apply to you, but this Act in particular does not apply. And for all the employers out there who are saying, how am I going to pay for this without ruining my business? That's the biggest issue of concern that federal tax credits are intended to address. The FFCRA paid leave requirement is intended to be fully funded by the federal government, and we'll talk in more detail as we progress today about what's the mechanism for obtaining that funding and how do you finance the payroll in the interim. But in general, an employer is entitled to 100% credit, fully reimbursable for the costs of either paid sick leave or expanded Family and Medical Leave Act as a credit against payroll taxes that would otherwise be paid to the federal government. So let's talk briefly about the emergency paid sick leave portion of FFCRA. The emergency paid sick leave portion of this Act provides for up to 80 hours of paid sick leave for if the employee is unable to work or to telework for qualifying reasons, which I'll review in a minute. The 80 hours is up to 10 days, and it's prorated for employees that work part-time. So if you have an employee that ordinarily only works 40 hours over a 2-week period, they would only get 40 hours of paid leave under the statute. The second aspect of the statute is, as I referred to, the Public Health Emergency Leave Expanded FMLA leave. And the basics of that are that it provides for up to 12 weeks of leave for individuals who are unable to work related to the closing of a daycare or public school or the unavailability of daycare for a son or a daughter. And the child can be any son or daughter up to the age of 18. This is due to COVID. I actually just misspoke and said public school. In fact, the statute applies to all school closings, not just public schools. What it provides to is up to 12 weeks of leave. The first 10 days may be unpaid, and the remaining 10 weeks must be paid by the employer at up to 2/3 of the employee's regular wages or salary, and that's up to $200 per day. So for $200 per day, 10 weeks of the 12 weeks must be paid. That's up to a $10,000 maximum. What are the qualifying reasons that an individual can take the emergency paid sick leave? The emergency paid sick leave is available, as I indicated, for up to 80 hours for a full-time employee or up to whatever 2 weeks regular schedule would be for a part-time employee. And there are a number of reasons that Congress set forth that emergency paid sick leave can be used. The key to all of them is that the employee must be unable to work or to telework because of one of these qualifying reasons related to COVID. The first is that the employee, him or herself, is subject to a federal, state, or local quarantine order or isolation order related to COVID. The second is that the employee has been advised by a healthcare provider to self-quarantine due to COVID-19. And this may be that they are not subject to an actual health department order, but they have an underlying condition and have some documentation from a healthcare provider that they should self-quarantine and should not be, and are unable to work because of that. Third one is if you have an employee who's actually experiencing symptoms that may be related to COVID-19, fever, cough, shortness of breath, any sore throat, any of those symptoms, and is seeking a diagnosis. So if you have an employee that's taking time off, unable to work, either because you've told them to leave and they are unable to be at the workplace, or because they've just reported to you that they're not feeling well and they're seeking a diagnosis. That doesn't require that they have to have personally seen a healthcare provider, but they have contacted a healthcare provider in order to determine if they have COVID-19. The fourth potential area that the 80 hours can be used for is for caring for an individual subject to quarantine or who's been advised to quarantine or self-isolate. Individual is not defined in the statute. So at this point, we as employment attorneys are assuming individual can be any individual. It's not limited by the statute to a family member. That may change when the regulations come out, but right now the statute simply says individual and does not define who that is. The fifth qualifying reason for expanded paid sick leave is when an employee is required to stay at home to care for a son or daughter whose school or place of daycare is closed or the regular daycare provider is unavailable due to COVID-19. There are numerous questions about exactly what that means, but the point of the expanded paid medical leave is 80 hours of paid medical leave can be used for that purpose. And when we get into the expanded FMLA, as I indicated earlier, the first 10 days can be unpaid when taken for care of a son or daughter up to 18. So the employee can elect to use the 80 hours of paid medical leave, sick leave, for those first 10 days of leave. If they do that, it does not expand the 12 weeks of total leave that they're entitled to under the expanded FMLA provisions. And finally, there's the catch-all provision, which at this point, none of us really know what it means. The statute provides that the Secretary of Labor, Department of Health and Human Services may determine that there are substantially similar conditions for which employees may be eligible for paid sick leave. At this point, we do not have any guidance as to what that is, and that is something that would have to be defined in the regulations that are forthcoming from the Department of Labor. What are the limits of the paid sick leave an individual can take? The limits on paid sick leave depend on the purpose for which the leave is taken. When we look at this page, the qualifying reasons, the first 3 reasons all relate to the employee's own illness or quarantine situation. Reasons 4 and 5 relate to the care for another. And as I indicated, reason 6 is undefined so far. But when we look at the text of the FFCRA, the amount of paid leave that needs to be reimbursed to the employee, and the rate at which an employer could get a tax credit depends on that leave. So when we look at those first three reasons on the previous slide, those are all for the employee's own illness or quarantine. And at that point, when an employee takes leave for those reasons, the employee must be paid at his or her full rate of pay, which is capped at $511 per day, or $5,110 total over the 80-hour period. If the employee is taking leave to care for another, because they're caring for an individual who's quarantined or are subject to isolation, or because of that school or daycare closure that we saw on the prior slide, the employee must receive paid leave, still 80 hours, but at 2/3 of his or her regular rate. That regular rate is capped at $200 per day then, or a total of $2,000 total. So the total amount, it's 2/3 of the regular rate of pay, and the amount that the employee can receive is $200 total, or $2,000 total. Those caps are important because they define what the employer is required to pay. If the employee makes less than that, you certainly can pay them less than that and pay at their regular rate of pay. They also define, however, what the employer will be entitled to a tax credit for. So one of the questions that I've received frequently is, well, if we have employees and we want to provide them PTO when they're working at the 2/3 rate, may the employer do that? Or may the employer simply pay them for that? And the answer is yes. However, when it comes time to be reimbursed by the federal government in terms of a tax credit against your payroll taxes, you will only be reimbursed for the maximum rates. Part-time, as we discussed, is entitled to the same sick leave. The caps are the same per day, but they're prorated based on the number of average hours that the employee works in a 2-week period. So the second aspect of the Families First Coronavirus Response Act is expanded FMLA leave. Expanded FMLA leave was debated by Congress as to what it could be used for prior to the final bill coming out. In some of the original versions, there was a provision that the expanded FMLA paid sick leave could be used for the employee's own illness. And the final version of the bill that came out provides only one reason that expanded FMLA may be used, and that is when an employee is unable to work or to telework due to a need for leave to care for a son or daughter under the age of 18 due to a school closure, daycare closure that's related to COVID-19. What exactly does that mean? This is one of the areas in which as I'm making this videotape, there is considerable ambiguity. And for example, are both parents, if they're employed by different employers, entitled to take the expanded paid FMLA leave? When is the employee unable due to work or telework because a child is at home? The FMLA itself gives us some guidance in regular FMLA when a married couple works or parents work for the same employer. In that situation, under regular FMLA leave for the birth or adoption or placement for child care of a child, the leave has to be split. We haven't been told, however, under these regulations that are forthcoming, we have not yet been told how is that going to be determined, which parent, if in a 2-parent household, would be eligible for the leave. And the other question that I've been asked a considerable number of times is, since the law allows for leave for a child up to age 18, how is it determined whether or not the parent's unable to work or telework due to that. If the parent did not have child care for the child before and would not typically have been home, is the parent entitled to the full leave because of a school closure? And that is something that has not yet been defined, and that we expect to see further clarification on in the upcoming regulations. The limits, as we discussed, are up to 12 weeks. And again, 10 weeks of that must be paid at 2/3 of the regular pay, which is up to a $200 maximum, up to $10,000. So when you coordinate these, the employee could conceivably get, if available, they could get up to $12,000 and 12 weeks paid. The 80 hours initial, which we provide for the first 10 days, at a total of $2,000, and the second 10 weeks would be up to $10,000. Now again, if the employee doesn't make that much in a day, the employer only need pay the employee's regular rate. What are some of the requirements that go with both the emergency paid sick leave and the expanded FMLA? Well, in order for an employee to be eligible for the leave, there are certain things that an employer may not do. And one of the things is the employer may not require the employee to find a replacement in order to be eligible for the leave. Employer may not require the use of other paid leave before paid sick leave. So if an employee has PTO or vacation or other paid sick leave coming, the employer may not require the use of that. An employer also may not retaliate against an employee for using any kind of paid sick leave or paid FMLA leave. In addition, an employer may not retaliate because the employee files a complaint that the employer is not complying with the FFCRA. So those are the things you can't do. What are the things that you are generally required to do? Well, you must restore the employee to the same job at the conclusion of leave. And the U.S. Department of Labor in FMLA, regular FMLA, includes the same job restoration requirement, which means if at the end of 12 weeks leave the employee is ready, willing, able to return to work, you are required as an employer generally to return them to the same or a substantially equivalent position. The U.S. Department of Labor has clarified in its frequently asked questions on the Families First Coronavirus Response Act that an employee who takes leave, as under regular FMLA leave, is not entitled to any greater job security than if the employee had not taken the leave. So if the employee would have been subject to a layoff, for example, or a permanent job elimination, the employee would not be entitled to job restoration because the job no longer exists, or the employee would have been temporarily laid off in any case. A word of caution to employers on that is, if you are going to rely on that as a reason not to restore someone to their job that they held prior to going out on leave, be judicious in making sure that you have documentation of why there's not a job available for that particular person. If you have 10 employees doing a job as a mechanic, for example, it would be risky to not restore to work the one person who took FMLA leave and restore the other 9 people. So make sure that you have documented reasons that this person is not being restored to their position. that's relatively easy if no one's being restored to work. But when some people are being brought back and not others, make sure that you can show that you weren't selectively picking out people who had taken advantage of the leave. Another requirement that is new to the expanded FMLA leave is the requirement that employers with under 25 employees continue to make contact and with an employee and make a good faith effort to restore that person to the position that he or she held before going on a protected leave. And the Act simply says that you have to, if you have openings, you have to reach out to that person for a defined period of time to see if they're interested in you, if you're unable to restore them to their original position at the end of leave. So what are the exclusions? Some of the exclusions that employers may have heard of and need additional definition for are healthcare providers or emergency responders. And the frequently asked questions that came out by the Department of Labor have broadly defined who's a healthcare provider for purposes of determining who may be excluded from the leave. And the definition is in number 56 of the frequently asked questions, which I'll give you a link to later, by the U.S. Department of Labor. And an employer may exclude employees from paid sick leave or expanded FMLA leave who fall under a wide variety of healthcare providers. It provides the FAQs, frequently asked questions, provide that healthcare providers, anyone employed at any doctor's office, hospital, healthcare center, clinic, nursing home, retirement facility, or similar institution, laboratory. It's an extensive list, and it does not limit that list simply to employees who are in direct patient care or licensed positions. The second question there is, who's an emergency responder? And the definition of emergency responder, we hope will be further clarified in the regulations that are forthcoming. But at this point, the definition is provided. We're provided some insight into what that definition might be in question 57 of the frequently asked questions, which again has a broad definition that goes to National Guard, law enforcement, correctional institution personnel, firefighters, EMS people, all those public health care people, but also includes individuals who work for facilities that are necessary to maintain the operation of the facility. So even if you're a behind-the-line support person in EMS or one of those first responders, you would be covered even though you're not directly responding to calls. And it also includes individuals with skills of training and operating specialized equipment or other skills needed to provide aid in a declared emergency. That is potentially a fairly broad exception. At this point, we don't know what the exact limits of that would be, but it could expand to people potentially beyond traditional emergency responders, such as potentially people who are required to maintain critical infrastructure like power systems. At this point, we don't know that. The frequently asked questions are broad, and the regulations should provide more clarity on that. Who else is excluded? Small businesses. Probably some of the most frequent questions I get are on how does this apply to small businesses? And I'll just make a few comments on that because we've entered strange new waters for many employers, because employers who have familiarity with the traditional Family Medical Leave Act, which has been around for nearly 30 years, understand that in the past, traditional family and medical leave has only applied to those employers who have 50 or more employees. that has exempted from any requirements of providing this leave any employer with fewer than 50 employees. What this statute says is if you have, based on head count, 500 or fewer employees, this applies to you. And that includes those small employers that may have 10 or 12, 15 or 20, even 3 or 4 employees. There is some relief in the text of the statute itself that allows for an exemption from providing the paid leave for employers of fewer than 50 employees. And the general text of the statute says small businesses may be exempted when imposition of the requirements would jeopardize the viability of the business as a going concern. That's what the FFCRA itself tells us. In its frequently asked question responses and its guidance, the U.S. Department of Labor has provided additional guidance for employers on what exactly does that mean. So if you're a small employer with under 50 employees, question 58 of the frequently asked questions put forth by the U.S. Department of Labor addresses this, and it provides some more concrete basis for from which to determine whether or not you're exempted from this. And the requirements are: a small business may claim this exemption if an authorized officer of the business, that could be your president, could be one of your board members, your board chair, anyone, so just someone who's authorized on behalf of the business to make the determination, has determined that, 1, the provision of the leave, paid sick leave or expanded family medical leave, would result in the small business's expenses and financial obligations exceeding available business revenues and cause the business to cease operating at even a minimal capacity. So number 1, the cost of it is simply greater, of providing the paid leave is simply greater than the revenues that are going to be coming in the door. The second example is the absence of employees or employees requesting paid leave would entail a substantial risk to the financial health or operational capabilities of the small business because of their specialized skills, knowledge of the business, or responsibilities. Essentially what that's saying is you may have an exemption for specific employees if they have specialized or key skills such that even though there may only be 1 or 2 of them and you may have a workforce of 25 or 30 employees, those employees have such key skills that in order to give them that paid leave or allow them that absence would jeopardize the operation of your business. And finally, the third potential exemption for small under 50 employee based employers is when that authorized officer of the employer determines that there just simply aren't sufficient workers available who are able, willing, or qualified at the time and the place they're needed to keep the business going. If there aren't sufficient workers to perform the labor or services that are ordinarily performed by employees that are requesting paid leave or expanded family medical leave, there may be an exemption and you can deny that leave. To clarify, the exemption for employers of fewer than 50 employees, the exemption applies both to the paid medical leave, that 80-hour requirement, and to that 12-week paid sick leave that may be used for school closures or daycare requirement. And the same requirements of expenses exceeding revenue, key employees, being out or not enough available employees to cover the work that I just covered apply whether the reason the leave is requested is for a school closure or for the paid sick leave. I want to briefly touch on the tax credits that are available, because the biggest concern of many employers is we would like to be able to provide this leave. In many cases, employers may be contemplating layoffs anyway, and there may be, this may be a way to get money in the pockets of employees that would otherwise be laid off. The issue, however, is who's going to pay for that and how are we going to cover that cash flow. And the guidance that we've received from the U.S. Department of Labor and the IRS provides that 100% of the paid leave that we've talked about, whether it's that 80 hours of paid sick leave or whether it's that 10 weeks that's paid of the 12-week expanded FMLA allotment, is to be funded 100% by the federal government. And the mechanism for the employer to be reimbursed by that is through a credit against employment taxes. And the IRS has explained that that credit applies against Social Security taxes that would otherwise be remitted on a quarterly basis to the IRS, but it also can expand to any indebtedness that the employer has for other employment taxes. So the IRS provides a guidance which explains that if an employer has an obligation of $8,000, for example, in payroll taxes and portions of withholding that it needs to remit to IRS, and it has a $10,000 cost for the cost of providing the paid sick leave or expanded FMLA leave benefit, that the employer can fully apply the total amount that's due to IRS for employment, including withholding, against that paid sick leave. If the amount that is due to the federal government in taxes is less than what the employer has spent in paid sick leave, as in the example I gave you, $10,000 cost for the paid sick leave and expanded FMLA versus $8,000 due to be remitted to the federal government, the employer can obtain an expedited refund of that amount. The forms for obtaining that expedited refund have not yet been issued, nor have the regulations for obtaining that refund. The IRS has attempted to ensure employers that it will get that money in employers' hands as soon as is possible, and possibly even on an advanced basis, in order to fund the benefits to be paid to employees. But the intent of the legislation is that it will be 100% paid for by refundable tax credits. Employers don't have to wait until they have, if they don't have sufficient taxes paid to recover the amount in another quarter, the excess in another quarter, the excess will be refunded to them on an expedited basis. And finally, before I go into some more specific questions and answers about the application of the expanded medical leave and expanded FMLA provisions of the FFCRA, I want to touch upon some relief for employers in terms of a guidance that the Department of Labor has issued on a temporary 30-day period of non-enforcement. The temporary period of non-enforcement does not start April 1st as of the effective date of the Act, in which you must provide the benefits to employees. It begins on the date of the approval of the Act, and it runs from March 18th, 2020 through April 17th of 2020. And what that means is if an employer acts reasonably and in good faith, the Department of Labor will not seek any penalties or enforcement action against the employer. And to act reasonably in good faith, the employer has to show that upon learning that it violated some provision of the FFCRA, that it took steps to remedy the violation and to make its employees whole. So if individuals were not paid correctly for paid leave, were not granted paid leave and had to take unpaid leave, or anything similar to that, the employer would be required to reimburse the employee for the benefit that would have been received. In addition, the employer has to show that the violations weren't willful. The definition of willful varies based on what statute you're looking at, but in general, an employer can't intentionally disregard the requirements of the statute or simply be willfully blind to them. Even if they didn't know it was illegal, they didn't take reasonable steps to learn what was required from the statute. And finally, an employer, in order to take advantage of the non-enforcement benefits, must provide written assurance to the Department of Labor that it will comply with the requirements of the statute in the future. So there is a temporary period of non-enforcement that will give employers and small businesses the advantage of hopefully seeing the final regulations, understanding what's required as this FFCRA compliance evolves and interpretations evolve. And if they learn they've made a mistake, to remedy that without facing any sort of enforcement action by the U.S. Department of Labor. I would encourage anyone viewing this video to get help. There are a plethora of resources. In fact, I'm sure you've all found, and I found, that it's difficult to stay up to date on the constant barrage of emails we're getting from governmental authorities, from business and industry sources, from law firms, etc., on how to comply with the FFCRA. The FFCRA the U.S. Department of Labor has provided a webpage with substantial information that's been updated sometimes on more than a daily basis. And the links that you're seeing on the slide right now, the first one is to the U.S. Department of Labor pandemic help page and FFCRA questions that I've been referring to, and I'll be referring to further in the question and answer period that will follow this. The second link is to the FM West Fargo Chamber and its COVID-19 updates. There's a wide variety of resources on that page, federal, state, that are very helpful, and I encourage you to take advantage of those. The third link that I'm showing on the slide is the North Dakota government response for COVID-19 resources and frequently asked questions. The frequently asked questions page by the North Dakota state government is being updated very regularly, and includes some prominent disclaimers on some of the pages that the situation is evolving, but it covers a variety of employer requirements, including things like what we've just talked about, the Families First Coronavirus Response Act, about unemployment benefits, about the CARES Act. We haven't discussed the CARES Act. The CARES Act is a substantial piece of legislation which provides for probably the things of most importance to employers are the payroll protection, the Paycheck Protection Program, and refundable loans that are available to employers to maintain payroll during the pandemic. There's also a employee retention credit that may be used of up to 50% of $10,000 in wages for employees of certain employers who've had a substantial, they've been subject to a shutdown, or they've experienced 50% or more reduction in quarterly revenues. The Paycheck Protection Act and the Employee Retention Credit can't both be taken together, but they're available. There's also, under CARES Act, an extension of available unemployment compensation and relief for employers. So, though we don't have time to address all of those details in this video session, there's considerable information on both the Chamber website, on the North Dakota State website, that will send you to the links that you need to know to get updated information on how to obtain those SBA loans, how to get those credits, what the unemployment benefits are, and what you need to do as an employer to qualify for those. And finally, I've included a link to our Vogel Law Firm website, which includes a COVID-19 resource page. There are several updates on there, including updates on FFCRA that we've covered today, an update on the CARES Act, including the full text of the CARES Act and links to resources for that, updates on tax credits, and updates on the North Dakota resources that are available. At this point, we don't have the Minnesota resources up there, but we are working on getting a separate page for Minnesota resources. They are included in a single page out there that we will update as often as we need to, of available links that will address virtually all the questions that you have, to the SBA loans, to the CARES Act, to the FFCRA, to the North Dakota Job Service, to the Minnesota Department of Employment and Economic Development resources on unemployment. So continue to refer back to those, and continue to take advantage of your chamber resources and also of your state resources, whether they're in North Dakota or Minnesota, for the available help that's out there, just to help you navigate this maze of new requirements, and also to take full advantage of all the assistance that's out there to help you with this. Thank you, and now I'd like to go through some of the questions that have been submitted electronically by some of our viewers and chamber members as to the FFCRA and COVID-19.